What's up, everybody? We had breaking news in the middle of the time that I was recording this video. I saw it first on X from Brian Enton that the grand jury has indicted Luigi Mangione in the United Healthcare CEO killing on a charge of murder as an act of terrorism. We're going to break down exactly what that means at the beginning of this video. It's very interesting. Once we get to the interview with Ben Chu, he has some very interesting things to say about will they even be able to convince a grand jury? Will they even be able to get an indictment without as much voir dire and questioning of these jurors as part of the grand jury? Will there be a rogue juror? So that brings us to part 2 of our video, which is that interview of Ben Chu, which is highly requested. And I also always think it's funny when you guys want me to react to somebody reacting to or talking about a case that is a lawyer. It's almost a bit of Inception, but I love learning, especially from incredibly successful and experienced lawyers like Ben Chu. So I love listening to what he has to say. I learn so much every time I listen to him. So hopefully as we watch this interview together in the second part of this video, we can learn together and you can get my reaction and see if I disagree with him, which I have from time to time. And that's always fun disagreeing. I think lawyers like disagreeing. So we'll see where I agree, where I disagree, and what we can all learn from this interview with Ben Chu together. Hit that like button and let's get to it. So after all this talk that Luigi Mangione would not get the highest charge, that first degree charge in New York, it'd be second degree because none of those enhancements would apply. Guess what? All the reporting was wrong. An enhancement applies. Even in New York, where second degree is like first degree, in a lot of other states, a premeditated act ending somebody's life can fit into that second degree box, but not today. We have seen the charges that are actually going to come down that the grand jury has indicted him on to include an enhancement. So let's take a look at how we got here. First, we're looking at the first degree statute, which we broke down together already when there were discussions about what he was going to be charged with. But when you go down and when you look through all these enhancements, we said, a government official, a cop, EMT, if you take the life of one of those people, that's how you get it bumped up to first degree. Well, guess what? There's another enhancement. Paragraph 8. If the victim's life was ended in furtherance of an act of terrorism, as defined in paragraph B of subdivision 1 of section 490.05 of this chapter. So paragraph B of subdivision 1. Let's hop over to that so we can see how in the world is this considered an act of terrorism? Let's take a read. This is subsection 1. This is paragraph B. But let's just read what all this is together, okay? An act of terrorism. This is defining things. A says, for purposes of this article means an act or acts constituted a specified offense as defined in subdivision 3 of this section for which a person may be convicted in the criminal courts of this state pursuant to Article 20 of the Criminal Procedure Law, or an act or acts constituting an offense in any other jurisdiction within or outside the territorial boundaries of the United States, which contains all of the essential elements of a specified offense. That is to include intimidate or coerce a civilian population, influence the policy of any unit of government by intimidating or coercion, or affect the conduct of a unit of government by ending somebody's life, assassination, or kidnapping. Okay? But here's paragraph B. For purposes of subparagraph 8 of paragraph A of subdivision 1 of section 125.1.27 of this chapter means activities that involve a violent act or acts dangerous to human life that are in violation of the criminal laws of this state and are intended to. So you committed a violent act that is dangerous to human life, right? Which is exactly what the person did to Brian Thompson, right? This is what Luigi Mangione is accused of, right? He's still presumed innocent, but this is the violent act that is dangerous to human life. Obviously, did he do it to intimidate or coerce a civilian population? Or did he do it to influence the policy of a unit of government by intimidation or coercion, or to affect the conduct of a unit of government by ending somebody's life or kidnapping? That is the question. Why did he do this? Was he trying to intimidate or coerce the population or a unit of government or a policy? I think our wheels can start to turn. And think about the manifesto. Why does he want to do this? What does he say he thinks he's going to do? How does he think he's going to make change? He's going to force change. Is the manifesto, is the motive in this case going to be enough to prove an act of terrorism to bump this thing up to first degree with the maximum penalties allowed in the state of New York? Incredibly interesting that this is what the grand jury has indicted him on, that this is what the prosecutors went for after all the reports were saying second-degree murder, when a lot of people just couldn't wrap their mind around it. Why isn't it first degree? For anybody that's followed stuff in other states, well, now you know. Second degree would be normal. First degree is extreme, is enhanced. And they have found their enhancement that the grand jury agreed with and has indicted Luigi Mangione on in New York. So much more to come on this. I can't wait to get my dad's take as well. Can't wait to read the comments and hear what you think. But let's get to that interview now with Ben Chew, which touches on this. It's very interesting to see that they've already come down with the highest potential crime in New York after there's some worry from a very experienced lawyer. And I even make some comments that maybe it would be harder in the grand jury proceeding because you don't get to ask as many questions. You don't get to voir dire the jurors quite as much. Will there be a rogue juror? Will the public pressure and all the support for Luigi Mangione, will it work its way into this grand jury room and the grand jury say, no way, we agree with him. We sympathize with him. We empathize with him. Jury nullification. We're not indicting this guy. Well, we have our answer. We have our answer. Let's get to the interview now. So actually, there's a presser going on right now about that indictment. So we're going to jump over to that and listen to what the prosecutor and law enforcement have to say about what they found, what evidence they have that Luigi Mangione did this, why they chose the charges they chose. More explanation than what we just got from myself and what I was hearing from the reporting. Let's hear what they have to say about it. This will be my first time watching it with you and getting my immediate reactions. We'll jump into this, and then we will get to that Ben Chew interview. I promise you my reaction on that is coming. But first, Alvin Bragg.
Good afternoon. I'm Alvin Bragg, Manhattan District Attorney. I'm honored and privileged to be joined by Police Commissioner Jessica Tisch. First and foremost, I want to extend my deepest condolences to Mr. Thompson's loved ones and colleagues. His family deserves our respect as they continue to grieve. Our work will never be able to undo the fact that a life was lost. We are here to announce that Luigi Mangione, the defendant, is charged with 1 count of murder in the first degree and 2 counts of murder in the second degree, including 1 count of murder in the second degree as an act of terrorism for the brazen, targeted, and premeditated shooting of Brian Thompson.
So interesting in how they word that, right? Because it looks at, the statute we just looked at, you get to first degree with that enhancement, but they called it second degree as an act of terrorism. So I don't know if that second degree as an act of terrorism is what bumps it up to the first degree. Maybe they'll explain that more, but I'm sure we will learn more about how New York does these charges. But at the end of the day, the question so many people had is answered: first degree and 2 counts of second degree. And I'm sure we're going to be discussing these charges at length in multiple videos to come. Can't wait to get my dad on, as I said, to break down these charges eventually. If you guys want to, which I assume you do, but let me know in the comments if you do.
As you know, was the CEO of United Healthcare. This case was made possible by the collaborative efforts of the phenomenal public servants you see before you today, and so many others who are not here. I'm honored to lead the Manhattan District Attorney's Office and privileged to serve alongside Assistant District Attorneys Joel Seidman, Kristen Bailey, and Zachary Kaplan, who were working from the outset, hand in hand, with the greatest police department in the world. Chief of our trial division, Lisa Del Pizzo, and the Deputy Chief, Chris Prevost, provided sage oversight and direction. And I want to acknowledge our high technology analysis unit. There was a lot to be processed here. Steve Moran, in particular, who heads that, and Marco Popic. We are privileged here at the DA's office to work every day with the phenomenal public servants at the NYPD. It has been a distinct pleasure to work besides Commissioner Tisch, an exemplary partner, And Chief of Detectives Joseph Kinney, almost every day we're in touch, and his leadership is second to none. And then Deputy Commissioner Rebecca Weiner, who, as I tell her, there are a lot of challenging things happening in the world, and I sleep better at night knowing that she is the Deputy Commissioner in charge of terrorism. The detectives on this, out doing the courageous frontline work, Detective Oscar Diaz, Detective Curcio, exemplary, the finest. It wasn't just those of us here in New York. I want to acknowledge the great work of our partners in Altoona, the Altoona Police Department, the Blair County District Attorney's Office, the governors of New York and Pennsylvania, the FBI, and of course, the brave members of the public who answered the call when our great commissioner put out the call for their assistance. This was a frightening, well-planned, targeted murder that was intended to cause shock and attention and intimidation. It occurred in one of the most bustling.
So it's just what we said before. Shock, intimidation, right? Those are the key buzzwords that are going to get it into terrorism. I can't remember what else he said. We're going to back it off.
Shock and attention and intimidation.
Okay.
It occurred in one of the most bustling parts of our city, threatening the safety of local residents and tourists alike, commuters and business people just starting out on their day. Let me say a bit more about the charges. They include 1 count of murder in the first degree as a killing in furtherance of terrorism, 2 counts of murder in the second degree, 1 charging that the killing was done as an act of terrorism, and a second pertaining to the fact that the killing was intentional. The maximum penalty possible for—
So again, all the questions people had, we get some answers, not all. We will continue to dig in and get more answers. This is all happening right now. Wasn't prepared for this. Just thought we were going to be talking about Ben Chu's interview, but let's listen to him explain it one more time.
Murder in the first degree as a killing in furtherance of terrorism, 2 counts of murder in the second degree, 1 charging that the killing was done as an act of terrorism,
Okay.
and a second pertaining to the fact that the killing was intentional.
Okay. So yeah, just the normal intentional run-of-the-mill intentional killing is second degree in New York, but there you heard it, first degree because of that terrorism enhancement, but there's also a second degree with a terrorism enhancement, I guess, which is just going to be interesting how they parse all that out. It's lawyer speak, it's lawyer work, it's how the statutes are written, but generally speaking, I think how I explained it in the beginning of the video is probably the easiest for just generally for us to understand how this is all going to work.
The maximum penalty possible for murder in the first degree and murder in the second degree as an act of terrorism is life without parole. The maximum penalty for murder in the second degree is 25 years to life. There are additional—
So generally speaking, with all these charges, he's looking at life without parole. Life without parole if you get that first degree or the second degree with the act of terrorism enhancement. Even just the run-of-the-mill second degree can get you 25 to life. So he's looking at life. No surprise there. There is no death penalty in New York. Also no surprise there.
Counts as well. A number of criminal possession of weapon charges, 2 counts in the second degree, 4 counts in the third degree, 1 count in the fourth degree, and a count of criminal possession of a forged instrument in the second degree. Let me tell you a bit about the facts. On November 24th, we allege that the defendant arrived in New York City to murder Brian Thompson. After the defendant arrived in New York City on a bus at Port Authority, he checked into the hostel on the Upper West Side using the name Mark Rosario with a fake New Jersey ID. On the morning—
And in these press conferences, this is the prosecutor laying out the case with no defense attorneys, no objections, no rules, basically. Just lay out the case. What are the allegations? What are you saying happened? What evidence do you have that you're sure of, that you're going to put out here in front of the public? Because if this is wrong, we've seen how this can explode in the prosecutor's face. So usually they don't share everything they have or everything they know, just a clean, clear, easy picture connecting dot A to dot B. How do we get here? How do we know it is this guy? How do we want to show that we can prove this case beyond a reasonable doubt? This is the first recitation of that.
Of December 4th, the defendant left the hostel, just after 5:30 a.m. and traveled to Midtown. For nearly an hour, we allege the defendant waited in the area near the Hilton Hotel, waiting for Mr. Thompson to appear. From 6:38 a.m. to 6:44 a.m., the defendant stood across from the entrance of the hotel on West 54th Street. When he saw Mr. Thompson, he crossed the street and approached him from behind. We allege he then took out a 9mm 3D printed ghost gun, equipped with a 3D printed suppressor, and shot him once in the back and once in the leg. The defendant then fled northeast on 54th Street and took an e-bike uptown before getting into a taxi that took him to West 178th Street and Amsterdam Avenue. On December 9th, the defendant was spotted at McDonald's in Altoona, Pennsylvania. The local police were notified. He was arrested, and he was found with a 9mm handgun a suppressor, 2 ammunition magazines, and the same fake New Jersey ID he used at the hostel. I want to say a word about ghost guns.
Before we get to the word about ghost guns, none of those facts are really surprising. None of those seem to be really additional to what I already felt like we've heard reported and what we know. So that can be strategic. Maybe they have more, maybe they know more, but why share things that aren't public? But even what's public right now paints a pretty good picture that Luigi Mangione's their guy. Is that how it's going to turn out? I don't know. But that's the picture they're painting. That's the probable cause they presented to the grand jury to indict him on the charges we're discussing here today.
These weapons are increasingly proliferating throughout New York City and the entire country. Involving technology will only make this problem worse. Last year, over 80 ghost guns and ghost gun parts were recovered in Manhattan alone. The NYPD and the Manhattan DA's office have been leading in the interdiction of these ghost guns. And one thing I want to make clear, they're unserialized, they can be printed out, but as this case tragically makes clear, they are just as deadly as traditional firearms. This will remain a priority for us here in Manhattan. Finally, I know there have been questions about the extradition process. The latest that I can offer you is that the defendant is currently scheduled to appear in court in Pennsylvania on Thursday morning, first for a preliminary hearing on his Pennsylvania charges. Immediately to follow that will be an extradition hearing. We have indications that the defendant may waive that hearing, in which case he'd be brought to New York forthwith.
We have indications that the defendant may waive extradition. I would expect him to at this point.
In any event, we have been preparing on parallel paths, and before the hearing, we'll send to the governor of the state of New York the paperwork that would be necessary if he does not waive during that hearing. I now want to turn over to our great commissioner, and when I do so, I wanted to thank her for her partnership, not only on this matter, but on all we do.
Good afternoon, everyone. The unsealing of today's indictment brings us one step closer to securing justice for Brian Thompson and his family and affirming the primacy of the rule of law in the city of New York. NYPD detectives worked tirelessly to piece this case together. And along the way, the Manhattan DA's office made sure we had every legal tool available to us. Whether quickly providing subpoenas to assist with our evidence collection or traveling with us to Altoona, Pennsylvania last week after the apprehension, our partnership made this a successful investigation. So I'd like to thank District Attorney Bragg and his team for their work in bringing this case forward. Part of that work included the relentless collection and analysis of surveillance video by our detectives, which ultimately produced a clear image of our suspect. That image was shared far and wide through the media, and thanks to an observant McDonald's customer and the employee who alerted the police, Mr. Mangione was quickly brought into custody. This outcome is why we always emphasize the critical role of the public in our public safety mission. So again, I want to thank everyone who saw something, said something, and did something. That is why we have a suspect in custody today. As DA Bragg said, Luigi Mangione is now formally charged and indicted for murder. And let me be perfectly clear. In the nearly 2 weeks since Mr. Thompson's killing, we have seen a shocking and appalling celebration of cold-blooded murder. Social media has erupted with praise for this cowardly attack. People ghoulishly plastered posters threatening the other CEOs with an X over Mr. Thompson's picture.
So when we get to the interview with Ben Chu and Jesse from Law and Crime, some very interesting additional elements and context to this that he discusses and is part of their conversation.
As though he was some sort of a sick trophy. And yesterday, the New York Post reported that some extreme activists were circulating a deck of cards with other most wanted CEOs to be targeted for assassination. These are the threats of a lawless, violent mob who would trade in their own vigilantism for the rule of law that protects us all. Let me say this plainly. There is no heroism in what Mangione did. This was a senseless act of violence. It was a cold and calculated crime that stole a life and put New Yorkers at risk. We don't celebrate murders and we don't lionize the killing of anyone. And any attempt to rationalize this is vile, reckless, and offensive to our deeply held principles of justice. Now, as we await the extradition process in Pennsylvania to complete, we continue our public safety work here at home. That includes our focus on the growing threat.
So she's not a lawyer, but you can kind of get the vibe and the idea of how prosecutors attack jury nullification in this situation and in this case. vigilantism, cold-blooded, taking someone's life, a family, a coward to stand behind him and lie in wait. You know, that's going to be the vibe, kind of the anger, the injustice of this, how misguided this is, how inappropriate this is. That's not what we do in America. That's the type of vibe that the prosecutors are going to come with. And Ben Chu, again, continue to tease that because it's really interesting doing this backwards, right? I did the Ben Chu interview before this. Ben Chu had some thoughts on this that I think are interesting as well. And I think the prosecutors would agree with.
Of ghost guns, one of which was used in this attack, the NYPD remains committed to tracking down and removing these untraceable weapons from our streets. And we will do that work hand in hand with District Attorney Bragg here in Manhattan and in every other borough to ensure that those who possess, distribute, and use these weapons are held fully accountable. Finally, I want to again thank every member of the NYPD, uniform and civilian, working on this case, led, of course, by our great Chief Kenny, whether in Midtown North Squad, Homicide, Crime Scene Unit, Intelligence Bureau, and everywhere else. All of you contributed to today's indictment, and you've brought the Thompson family one step closer to justice in this case. Thank you.
We're not going to be able to hear the questions, so we'll get the context from the answers.
Sure. So, in its most basic terms, this was a killing that was intended to evoke terror. And we've seen that reaction. The statutory elements we can go into, but its most basic term, that's what this is. This was not an ordinary killing, not to suggest that any killing is ordinary, but this was extraordinary. And the New York State Legislature has, set out, both the paths that we talk about, both murder one and murder two. And this, we allege, is certainly squarely within those statutes, which talk about intending to do exactly what we saw happen here.
Probably could have been more prepared specifically about how this was intimidating or trying to coerce some sort of, government act or policy or the civilized population, like specifically what the statute states that we just read together and how this fits in from their perspective and how they're going to be able to prove that this fits into that enhancement. Because you better believe it's a criminal defense attorney coming in there. It will be considered a win potentially if they can beat the terrorism enhancement and just get it down to second degree potentially. I don't know if the prosecutors would be okay with that kind of split the baby type of verdict, but they're going to have to prove how it fits into that enhancement. They can't just say, oh, it invoked terror, and generally speaking, that be enough. I'm sure there's going to be more. Was hoping for, more of an in-depth answer there before I even knew this press conference was a thing and what I mentioned earlier on.
Report took place. So the original missing report took place back in November 18th in San Francisco.
So they're asking about, I'm surmising from the context, I've heard reported that his family reported him missing. Luigi Mangione's family reported him missing. And I believe they asked when that happened, and he just said November 18th. So about a month ago.
The sergeant that was involved in that case reached out to the San Francisco field office and said, hey, basically, I'm working on a missing case. I saw the photograph that was distributed by the NYPD. There bears a resemblance. That tip was forwarded to us close to 45 hours after the incident took place. It showed up to a TFO, which is a task force officer. We have NYPD officers embedded with the FBI. They received that tip. It was one of 4 tips that they had received that day, and they were vetting it. Part of that vetting process was that they reached out to Mangione's mother in San Francisco very late on the 7th. They had a conversation where she didn't indicate that it was her son in the photograph, but she said it might be something that she could see him doing. So that information was going to be passed along to the detectives the next morning. But fortunately, we apprehended him before that we could act on that.
The commissioner has talked about how the defendant's been lionized and celebrated. I'm wondering how concerned you are about a potential jury knowing that someone on that jury would be someone.
Concerns, which I think were put forth beautifully. And we see a lot in these jobs. I meet with the families of homicide victims, and I just can't wrap my head around the notion that someone is celebrating this. To your specific question, we're at the beginning of a litigation now with our charge. We have a phenomenal trial team in place, led by ADA Joel Seidman, who has been in this office for more than 40 years and handled some very challenging matters. We have a voir dire process in place. I have faith in our jury system to select 12 people who can be fair and impartial, but we'll move forward, and that's something well down the road, but we'll be ready when that time comes.
Two questions, if possible. One will be about Mr. Thompson. But first, I want you just maybe to explain more to viewers how you come to the conclusion that I think it's one part of this. And so I'm hoping maybe you can explain that a little more, sort of define the statute.
Sure, and my point, I mean, the statute talks about attempts to influence or coerce a civilian population. The statute talks about intending to influence a policy of government, and it talks about seeking to put forth things sort of similar to that by murder. So the statute, the plain language of the statute is clear. Obviously, we've charged it, the grand jury has voted on it, and we intend to go forward and prove it. But I think it does help to take a step back and think about the proof in the case, some of the writings. I'm not going to get into too much of that, but and the actual reaction.
So they're, again, I think they're focusing on that terrorism enhancement. They have these writings that he's not going to go really into detail about that. We don't know all the details of, because there was that spiral notebook. But again, no surprise that they have a lot more than we know about at this point.
In the middle of Midtown, the beginning of a busy day, tourists, commuters, business people, the intent was to sow terror.
Sadly, as you say, not a lot of focus.
And if you remember, they talk a lot about chemical weapons in the statute, and when that was a thing, right? Anthrax and sending envelopes with that and whatever, like those were acts of terror to cause terror to, again, civilization, to the population, to the people. And this was, kind of a vigilante, a voice of the people, but still causing terror to some people and for certain policies or conversations, or even to try to force the government to do something. Those are all going to be things I think that are going to be at play in this case, depending on how the evidence develops.
I'm not going to talk about communications with the family other than to say that we have a robust survivor services staff here that is second to none, but I would not talk about communications with any family. I don't think it'd be appropriate. But I appreciate your concern.
Well, it's just because, like you're saying, there's so much focus on the suspect. It's quite different.
I echo what the commissioner said, and the sentiment of your question, my heart goes out to it. I mean, this is a significant piece of what we do here, is we center the trauma of survivors and victims and their families. A significant piece of what I do is sit across the table and look people in the eye, and when appropriate, if they want to, offer a hug. And we have dedicated advocates and counselors and great staff that focuses on that. So I agree completely with you. And I wish that that's where the public's focus was exclusively. That's where it should be. That's where it is here, in addition to obviously the facts and the law in the case. But because of respect for where your question's coming from, I'm not going to get into communications.
Yes, absolutely. And we've seen a real increase, sustained increase since December 4th in concern, not just from CEOs, but from corporations broadly. And so going back to the DA's point, the intent to intimidate or coerce a civilian population, which is, of course, at the root of our state terrorism statute, is very much borne out in this reaction. And for good reason. We've had a torrent of online threats. We've had real world activity that the police commissioner flagged, which is abhorrent, and it causes concern. So we have done a lot to work with corporate security partners with whom we partner on a daily basis in this city, at the city level, at the state level, trying
This is a better explanation of how we get into the act of terrorism.
to make sure that everybody has the best practices that they need, that they know where to flag not just general ambient concerns, but specific threats that they might be receiving that a few weeks ago they might have written off as just noise in the online environment, that they now take seriously. So these are ongoing conversations that we have, and thanks to all the work that we do together every day, we're quite confident that concerns and threats are going to be appropriately directed our way.
very specific cases in Manhattan. And also, you speak to the statements made on the record by the suspect that informed his timeline, in particular, his meeting with incriminating statements that happened.
So I'll address the first piece. The first degree murder statute has a number of subsections. They're sort of clearly delineated, and they are reserved for the most abhorrent conduct: killing a police officer, serial killing, and the terrorism is one subsection of that. And so I would say, fortunately, that's not happening a lot. Taking a step back, I can't think of another office that is more equipped to handle a terrorism charge. We have a great terrorism unit. We were at the forefront of getting the statute passed. Within the last 2 years, we've tried 2 very significant terrorism cases, one involving an English-speaking operative based in Jamaica, and another involving someone who was here and funding overseas terrorism by cryptocurrency. So we have the expertise, and as I mentioned, the expertise on this team, and so we're prepared to go forward. I'm not going to go beyond what's in the filing.
All right, last question, Laura.
Which is a telltale sign that there is more than what's in the filing.
So as a matter of practice, I don't talk about sentencing outside of court as a first matter, and certainly not at the initial stages of a matter. But I think you can tell the seriousness with which we take this matter by the way in which it's charged. The murder in the second degree actually has a mandatory life without parole sentence, no discretion for the judge at all. So that's the maximum there. But I'm not going to go beyond that. We will first get the defendant to New York. We will have him arraigned. We will be before our judge. And we will engage in pretrial litigation. If there's a trial, we're ably equipped to do that. And then we will proceed to sentencing, at which point we'll make our arguments in court. Thank you all so much. I was taking your book.
All right. So a lot more than we expected in today's video. It's going to be a little bit of a longer video, so hopefully you're ready for some overtime. And let's finally get to the Ben Chew interview as promised in the beginning of the video. All right, so we are going to jump right in and listen to some of the questions that are asked of Ben Chew. Let's remember that Ben Chew is I think, lifetime civil attorney, but he is a litigator. He is a trial lawyer. He's very smart. I'm sure he's got a lot of friends that practice criminal defense. I'm sure he's part of a lot of groups and organizations that intermix in the rules and understand how the courtroom works, how case law works, how statutes work, how defenses work, how arguments work in court. But most importantly, how the media in a very high profile case where the world is going to be watching and you have everyone's attention and how to deal with that from a lawyer's perspective, he may know that better than anyone. So I love listening to him. I love getting his perspective. I always feel like I can learn something from him, and I am a lifetime learner. So I always want to continue to learn. So we're going to watch what he has to say, and we'll see where we agree, where we disagree, and what we can take from this interview.
To fight his extradition to New York. And there are a lot of moving parts to this. So with such a high profile case, we thought, let's get some perspective from a high profile lawyer, Ben Chew. I mean, talking about a case that everyone in the country and abroad was watching, Johnny Depp. It's great to have your perspective because almost every eyeball is focused right now on Luigi Mangione. Thank you so much for coming on, Ben. Good to see you.
Great to see you, Jesse.
So I have to start with your thoughts on the amount of money in this legal defense fund that's been raised for him. You know, look, he is a criminal defendant. He is innocent until proven guilty. And despite the message that they're not advocating violence or supporting violence, don't you find it interesting that so much money has been raised for the suspected shooter of a CEO of one of the largest health insurance companies in the country?
Yeah, I find it stunning on two levels. One, because of the nature of the alleged underlying crime, which is just cold-blooded murder. And two, that he apparently is of a very wealthy family. So I'm not sure that he's not an indigent defendant.
And he brings that up because of all the outpouring of financial support, right? I think it's interesting because the reports came out that he's from a wealthy family. But I don't know that people knew that in the beginning, right? Maybe when they started donating. I don't know how much that has dissipated to the masses. It's definitely becoming more apparent now. And I think what Ben Chew is saying is like, he doesn't need it. So why are you doing it? Maybe it's a weird flex. Why do you want to get behind a cause like this, the suspected shooter, as they say, he is innocent until proven guilty. But I do think the groundswell of the public support is more about maybe the manifesto or the big picture issue on health insurance or insurance companies generally, and people not liking them and thinking they're killing the little guy and their denials are so unfair. We've seen allegations of somebody else writing deny, defend, depose, and there being some criminal charges with that, which that kind of blows my mind. So if I want to say something like that in a closing argument, that they denied my client's case, they defended it, they deposed her, they try to make their life miserable to try to save money and not pay money as a $1 billion insurance company, that's a crime. Like, we got to be careful depending on what the context is of all of this. But I do think that if he was indigent, it may be different. But the fact that he's from a well-to-do family, people are really purposefully getting behind this cause. And is that a good thing? Is that a bad thing? Let me know what you think in the comments. And we're going to hear what Ben Chu thinks.
From a wealthy family and probably doesn't need that money for his defense fund.
Does it bother you that this money has been raised, or you say, hey, listen, look, any criminal defendant is entitled to a defense, and maybe his family, maybe, I don't even think it's anybody's, look, I can't speak for everybody, but I don't even think it's about, hey, we know you don't have the money, but maybe this is a sign of us showing our support for you in your case.
Yeah, Jesse, I certainly agree with you that everybody is entitled to the best defense possible. And the more serious the offense, the more important it is for him or any criminal defendant to have really good defense.
So we all agree there, right? Completely agree with Ben Chu that every criminal defendant deserves the best attorney they can get, and they deserve the best defense that their case allows and that the facts allow in their case. Not to lie, cheat, and steal, but to present the best defense. And that might just be holding the government to their burden. It could be an affirmative defense like self-defense, insanity defense, whatever it may be. But each individual case deserves the best defense attorney and the best defense that a citizen of our country deserves. It is a right. We've got to make sure, especially as lawyers, we stand up for that right. I got home from my office not too long ago and had to change immediately. A lot of you guys are going to be annoyed at me or frustrated at me, and I get it. The AC broke at the office, and it was so hot. I was sweating in my office all day today, which I know annoys many of you who are probably sitting in the snow. Maybe you had snow days. I don't know. Let me know in the comments how cold it is or what the temperature is from where you're watching. But I'm so glad to be nice in the ice cold AC of my home studio here. And we'll continue on.
But it is disturbing that this really isn't about the facts of the particular case. It appears to be about a coarsening of our society that this act can engender so much support.
And what do you make, and I'll get to that a little bit more because something happened in Boston I have to bring everybody's awareness to, but what do you make of him selecting Karen Friedman Agnifilo, who, by the way, for anybody who's been following Sidebar, she is married to Mark Agnifilo. He's representing Sean Diddy Combs in his federal case out in New York. So you have a very high-powered couple, legal couple, but what do you make of him retaining her? This is somebody who has experience in the Manhattan DA's office.
Well, it shows that he is quite sophisticated, or he has access to sophisticated friends, which is not very surprising in light of his background. He's a graduate of the University of Pennsylvania, so doubtless he has friends and associates who have access to knowledge and who know who the go-to lawyers are. So that part of it doesn't surprise me too much.
What advice?
So that was kind of an interesting comment. Ben Chu said he's sophisticated and he has access to sophisticated people or sophisticated friends, something like that. And it's an interesting point. So the vast majority of lawyers, just like the vast majority of people, if you have enough money, you can get access to them. But there are certain lawyers. I'm not so sure these lawyers are those lawyers, but there are certain lawyers that even an unlimited amount of money cannot get you access to them, right? If they have a limited case volume that they're willing to take and they're not taking any more cases. There's a very small number of lawyers that happens to. I also, reading the comments of my prior video talking about Luigi Mangione's lawyer, Puff Daddy's lawyer, whoever it may be, and some people said, oh, New York lawyers are the worst, New York lawyers are the best, whatever it may be. There are really smart and very successful, great lawyers in big cities like New York and LA, But there are also some very, very successful and amazing lawyers in some small towns, in some rural states, in some rural areas that choose to be there, right? Not everybody's a big city person. Some people would say it's, most people don't want to live in a big city, but I think it's important to understand that there are amazing, great lawyers in Virginia, Washington, D.C., Florida, Texas, LA, wherever it may be, Nebraska, and it's just choice of life sometimes. So we can't just assume that because somebody is in New York or is not in New York, that they're a great lawyer or a bad lawyer. And I think that is important to say, but I thought it was an interesting point for Ben Chu to say sophisticated access to certain people can be difficult, and he gets access to at least these people that he needs in his corner.
Go-to lawyers are. So that part of it doesn't surprise me too much.
What advice would you give her? Because a spotlight is going to be put on her the same way a spotlight was put on you and the rest of the lawyers in the Johnny Depp Amber Heard case. I mean, you guys were like the main stars. I mean, everybody knew about you guys, knew about your past, were following you. You walked outside of the courthouse. People were cheering. People were coming up to you. I mean, this is going to be probably her most high-profile case that she's ever covered. What advice would you give to her?
I would advise her, keep it simple. Go ahead and do what you normally would do. And remember that, and you've heard me say this before, he is your client and you are representing him. So do whatever is in his best interest and try to block out everything else. You can enjoy.
So this is where he's an expert, right? And sometimes it's one big trial and you become an expert and it is what it is. And so he's the expert on this. And so he says, block as much out as you can, do what you would do for any client. Great advice in my opinion. I think the lawyers that do this do the best jobs for their clients. We've seen some cases where lawyers let some of this get in and it can be frustrating, but also, and I'm interested to see what he says, do you use it to your advantage? Is it a tool? Watching these videos, what can you learn? Because you want to take it with a grain of salt, right? You don't want to do, just because one commenter says something, you don't want to build your defense around it. But if the masses are saying or doing something, how does that affect your defense, your strategy, what witnesses you might call, what arguments you might make, what documents you might try to get? Does that affect your case at all? Because from my perspective, it would be a tool I used. It wouldn't be the number one tool. It wouldn't be the only tool, but it would absolutely be a tool I use. We heard Doug Weinstein say how a lot of the comments he would see if they were misunderstanding something, if he could use it in cross-examination, and it would be part of what he did to continue learning and getting information in his head that could be helpful to his client, while of course doing it with a filter and taking everything with a grain of salt.
Enjoy, the accolades, if there are any, after the case is over. But her case.
So that was a good point. I'm going to back it up so we can hear that again. He's like, basically, don't drink your own Kool-Aid too early. If you get accolades after, sure, take your victory lap at the end of the game, not in the middle of it. Don't worry about if everybody's saying what a big shot lawyer you are, or how great you're going to do, or you're definitely going to win. Forget about all that during the case. If you win and you get some accolades and some praise after, then you talk about it. I think that's great advice for life. First off, that's great advice for life. Don't celebrate your victories before they happen. And frankly, let other people talk good about you, right? Let other people say what a great job you did, and then say thank you. And I think that's great advice just in life, but also, as he's saying, in these high-profile cases.
Try to block out everything else. You can enjoy, the accolades, if there are any, after the case is over. But her case, her job is to be laser focused on whatever is best for her client. And I'm sure she will be. There's no reason to think she'll be anything but dedicated to his best interests.
Can the public's reaction, the reaction online, be a distraction to the case at all? Could it be problematic representing a client like this?
Definitely. If she pays more attention to what she's seeing on social media, yeah, it can definitely be a distraction. And for example, I don't think she should take much heart in sympathy coming in for her client, this anti-insurance company, because I'm not sure that it's going to help him ultimately, either in the grand jury or in the jury, because
So that's interesting. He said, don't put a lot of stock in the public support, basically, or sympathy for your client, people who may be empathizing with his cause, because he doesn't think it's going to help him in the grand jury or with the actual jury. And that's something I've said kind of from the jump. is I'm not so sure actual jurors are going to feel the same when they start talking about Brian Thompson and his family and his life, right? Versus this cold-blooded act that was done. And, it sounds like Ben Chu feels the same way. Now, there are some interesting aspects to it that I think he gets into, and we'll discuss as well.
Play either in the grand jury or in the jury, because I have I know we're getting to this, but I think she needs to stay laser focused on what his best legal defense is going to be and not rely on any support from social media, because that might be helpful in the media, but I don't think it's going to necessarily help her client.
So it sounds like he does not think jury nullification is going to be a good path to take. And I will tell you, I don't know how many lawyers are really going to get up and say, fight, push hard for jury nullification, go for jury nullification, look at what the public is saying, listen to the public. I mean, I've said that on cases, right? Listen to the public. They're saying X, Y, and Z, especially in the YSL trial. It's like that went away that not a lot of people expected it to go, and the public was seeing it that way for a long time. Johnny Depp, kind of a similar thing. But not every case is the same. That's why there is the phrase case-by-case basis, which so many legal decisions are made on that. And this is one of those situations that it's a case-by-case basis. And just because there is this loud public support for him, which again, I can empathize with the cause too, and how frustrating insurance companies are and how horrible they are and how they hurt the little guy so many times and feeling like you're helpless and powerless and you can't do anything. I get it. But this is an extreme step that when the rubber meets the road, I don't think the people that need to be on board with that, meaning the jury, will be. There could be some rogue ones, and I think they're going to get to it eventually, so we'll talk about it.
So I am confident to say, from a legal point of view, and I'll get into a list of the evidence, there is enough evidence for probable cause to get an indictment back in New York on second-degree murder and weapons possession charges.
I'll say based on what we know, I agree with him. There can be still a lot we don't know, but based on what we know, it sounds like there is enough for probable cause. I would agree with that.
I'm confident in saying that. I will say legally there is enough probable cause because it's a lower standard. It's not proof beyond a reasonable doubt. It's just, is there enough evidence to suggest that potentially a crime was committed? Probable cause here to move this forward, to get an indictment. But let me go back to my main question. Despite all that, there is this, I don't know what the word is, sympathy or understanding or praise for Luigi Mangione, assuming he's the one who committed this crime. And I wonder, would a grand jury, and you and I both know that there's not necessarily a voir dire process with grand jury as there is with an actual trial. Would they look at this and say, you know what, I don't want to indict this guy? What do you think? Is that crazy I'm thinking like that?
No, it's not crazy at all. And it's a great distinction you just made about the lack of voir dire in a grand jury as opposed to a trial on the merits, because if to the extent that he gets to trial, I think there are ways of weeding out those people who might be tempted to engage in jury nullification. It's not foolproof.
So that's the point, right, that I wanted to get to. Weeding people out that may be, pushing jury nullification or go rogue or be somebody that really doesn't want Luigi Mangione to get convicted, believes in him, something happened to their family member, whatever it may be. Voir dire is going to be as important in this case if it goes to trial, which again, I think there's some indications that it might not. Probably save that for another video. But if this goes to trial, voir dire is going to be incredibly important, almost more important than any other case for the prosecution because of the potential. That's why you use the public outcry and the push and the outpouring. You use that to weed the people out that would get into that boat if you are the prosecutor's office, because that is absolutely something you can disqualify somebody for if they say they will not follow the law because they believe in his manifesto or they believe in the reason for why he did this, or they think insurance company CEOs should die for this. If they believe that, then they will not follow the law. That is a for-cause challenge. They are out. They cannot be a juror on your case. So that's important, right, in the voir dire process. But Ben Chu brings up a really good point. Some cases, there is one rogue juror. There was reports of this in the YNW Melly case out of South Florida. I don't know if you guys remember it, that one person refused to convict. Well, that's possible here. And what that would do was create more of a situation for a hung jury in a mistrial than a not guilty verdict if there's just one rogue juror. It is very difficult to get a jury of 6 to 12 to all agree unanimously on jury nullification to vote not guilty on a crime they all kind of agree that a defendant committed and should be guilty for. So it is very, incredibly unusual.
But I'm confident about that. But I think the prosecutor should be skilled enough to say, look, you need to put aside any animus you have with respect to insurance companies. This was somebody who was gunned down in cold blood, a man who had a wife, who had kids, and that's what you need to focus on. And to the extent you have sympathies, well, that's something that the next jury can consider. Your job is just to determine probable cause. And I think, and I'm speculating, and you may well be right, maybe there will be jury nullification at the grand jury level, but I think they are going to indict him under these facts.
And it's a great point that it may be more difficult. Usually you can indict a ham sandwich, right? But it may be more difficult to weed out the people that would be extreme on his side. So that's kind of an interesting process, right? That the grand jury may be more difficult than the trial for prosecutors because there's not as much of a voir dire process, although there still kind of is, and they can still control the process so much that I would still be surprised if he wasn't indicted. I would be very, very surprised.
Let's explore that. So maybe he'll be indicted, maybe not, because let me give you an example of what I'm talking about. It's been reported there was this dance party that was being held called the Bop to the Top Tours Jingle Bop that was held at this venue in Boston called Big Night Live. A lot of people. And the DJ ends up putting on the screen pictures of Mangione. The crowd just starts cheering and going nuts. One of the clips was shared on TikTok, and it has now over 1.2 million likes. So when I think about this, let's say, Ben, let's say a grand jury does indict him. You talked about there might be ways during the jury selection process at a trial to weed out maybe stealth jurors who want to go on there and get him off, or jurors that might have a bias against the health insurance industry or have sympathy for this man. How do prosecutors look into all these jurors? Do they go on their social media accounts? Do they ask them questions about their relationship with the health insurance industry, their family's relationship?
So some of that depends on the courts, the jurisdiction, the judges. Not every jurisdiction, like we've had federal court judges tell us, you are not allowed to look into the backgrounds of your jurors. You're not allowed to go look at their social media. You're not allowed to do things like that. And we've fought it and lost in federal court. So depending on how things go, I mean, assuming there's not going to be cameras in this case, if it's in New York, right? Because most of the time that doesn't happen, even in state court there. But that would be a good question for Bettero, right? That'd be a good question for Bettero. How much are you allowed to look into jurors as criminal defense attorneys and prosecutors? Because I think you'd be able to learn a lot about a juror and how they feel about these issues in this case based on their social media. And just based on asking them questions, I mean, in voir dire, this could take days, depending on what the jurors' answers are for what they feel about health insurance, the insurance industry in general, medical bills, medical debt, so many different scenarios to get into whether or not they agree with this vigilante justice. I mean, it would, I hesitate to say fun in something like this, so I don't want you to misunderstand that, but it would be kind of a fun and a kind of a captivating voir dire digging into these issues. It's kind of an interesting and different set of subjects and circumstances to talk about in voir dire that are so outside the norm of many cases. If it's an insanity case, if it's a DUI, if it's a family tragedy case, or, you know, we've had some like cult cases where they'll get into religion and things like that. Very interesting. And this set of circumstances, to me, there's so many different ways you can go where I can ask a question over here where you might not even know that your answer is giving me a direction all the way over here that I can use in determining whether or not I think you'd be a good juror for this case. So this is one of those where I think there's a lot of strategy in how the lawyers would do the voir dire.
How do you weed out jurors? Because it's not like a change of venue would solve a problem. The health insurance affects everybody in the country.
Yeah, that you put your finger on it and poked a hole in my thesis, because I think you're right. I think it's going to be very difficult to do that, and I'm not even sure it's worth the effort. I think you just have to you have to present the facts and hope they're willing to do the right thing, because I think you're right.
Oh, I think you can weed it out. I think you can weed it out, especially because what we're saying here. So I guess this would be a little part where I would disagree with him or agree with his initial thoughts, because he's kind of gone, as lawyers do, we go back and forth, we kind of weigh options and take in more evidence and make decisions. But I think that there are so many indicators. If somebody's on the extreme side, if somebody's like me and they hate health insurance and they hate car insurance, and insurance companies are always trying to make a buck and it's profits over people and they're greedy. A lot of good people work in insurance, good CEOs, good adjusters, good. I'm not saying everybody's bad in it, but generally speaking, as an industry, it feels greedy and profits over people. People say that about lawyers too. Okay. We can have those discussions, have open discussions, but people can feel that way about insurance companies and still not think this is okay. So you've really got to get out the extreme ones who think do anything to hurt these people because they're trying to hurt us. It's us or them. Like, you can get to that without saying everybody that has a negative feeling about insurance companies or health insurance or medical bills has to be out. It doesn't have to go that far. So I think it might be somewhere in the middle of where they're at.
That level of antipathy is probably spread throughout the United States, and you're not going to get a change of venue anyway. I mean, this is where the crime took place.
By the way, how much of it is also based on his looks? It's one thing, the idea, let's call a spade here, but it wasn't just what he allegedly did, but he's also an attractive guy who's physically fit. That's a factor. How does the defense and how did the prosecution work on that? Because that could help him.
I will say this tracks based on comments on my videos and what I'm seeing on social media. It tracks that being good looking is seemingly helpful for him. What do they call it? The pretty privilege or something? I watched a video on YouTube of somebody like making a hilarious, just like sarcastic or satire about the pretty privilege, but seems to be hitting hard for him.
Defense and how did the prosecution work on that? Because that could help him.
No question about it. I think you're exactly right. And his physical appearance, he likely, well, he's not going to be testifying, but he is,
Good.
there are aspects certainly that are about him that are appealing, and his appearance does matter for sure. It does matter in any trial, civil or criminal. How your witness, how your client looks is very important.
So that's interesting. Also, if we remember back to the Johnny Depp trial, what he wore, how he did his hair, where he was looking, his expressions, how all the lawyers dressed, Amber Heard, their witnesses, how important all that was, right? And he's given us a little window into his mind, is how he prepped for that case and how important that is. And, just with that explanation, you can apply it to his cases as well. And I agree with it. How they appear is important. Not always like being good looking or attractive, but being cleaned up. You're taking it professionally. You're taking it seriously. You're not cracking jokes. Facial expressions are really important. What a defendant is doing, looking, how they're reacting is incredibly important because everybody's watching, especially the jury. So that's an echo of that.
I wonder if the prosecutors say this is a wealthy, privileged guy. He shouldn't be praised. He had every opportunity. I wonder if prosecutors can kind of try to paint it that way.
I have had prosecutors say, this person thinks they're above the law. We've had, attractive doctor clients who do get accused of X, Y, and Z. And some of the closing arguments for this doctor thinks he's above the law. Because he's a doctor, because he's wealthy, because he's good looking, because he has X, Y, or Z, drives this car, he thinks the rules don't apply to him. So that absolutely, it's a good question from Jesse, because that absolutely has been a theme of prosecutors closing arguments in trials I've done myself. So that is a real thing.
They should. And that was kind of, I was trying to.
I'm going to back it up. Ben Chu says he thinks they should. That is what the prosecutors do. Hold his pretty privilege against him.
Kind of trying to paint it that way.
I think they should. And that was kind of, I was trying to touch on that earlier. I mean, yes, there are some appealing aspects of him, but there are a lot of non-appealing aspects. And I think the fact that he was a rich kid from Maryland who went to private school, I think that can be used against him. He had options, and by the way,
so the only way that can be used against him is if he tries to use it for him. You get what I'm saying? The defense would have to bring up oh, he couldn't pay his medical bills. He was in medical debt. He had this surgery. He got angry. They denied his claim. And this is what happened. He snapped, insanity. The defense would have to bring up the argument in order for the prosecution to respond. Rich, good looking, privileged kid who had everything at his fingertips, because if the prosecutors don't bring that up, if the defense doesn't bring that up, the prosecutors have to show why that's relevant to pulling a gun on somebody in not broad daylight, but you know what I'm saying, to pulling a gun on somebody and doing what he did in public. And so from my perspective, I don't know how that's going to be relevant necessarily just off the jump. Maybe they'll find a way and they'll have to show how that's relevant. They can't just say, I guess they could. There are some ways, I guess, you could try to work it in, but I think it's dangerous. And I think, saying this privileged kid is a little brat and, he did this doesn't work unless he goes, woe is me, poor me. And they say, yeah, right. There are people actually dealing with medical debt. There are people who are actually getting denied treatment that they need. There are people whose lives are actually affected by this stuff. And you weren't one of them. You just wanted to be famous. You just wanted to go big or X, Y, and Z, whatever it may be, which that could also be dangerous. You're seeing the mind of a lawyer work, right? Just thinking of arguments on both sides. That could be dangerous to admit that there are people whose lives are actually seriously negatively affected by insurance companies putting profits over people. So you got to be very careful with how you tailor these arguments on both sides of this case, because you never know. I'll tell you one thing you never know as a trial lawyer. You never know what's going to strike a chord with a juror. When you say that one thing and they're like, you're right, I hate that insurance company. So it's like the prosecutor says, oh, this rich kid doesn't care. There are people who are actually devastated by medical debt because their insurance is screwing them. And the juror's like, you know what? Screw this insurance company. Let this guy go. And you think it was going to work the total opposite way. Got to be careful.
I don't believe he even was ever enrolled. I don't think United Healthcare was his insurer.
No.
And so that's an allegation I've heard. I haven't heard that confirmed, but they're talking about how he didn't even use United Healthcare. That wasn't even his insurance company, which opens up so many questions. Number one, how is it relevant then what United Healthcare does? Right? This isn't affecting him. If it's an insanity defense, how did he come to this moment? I don't really get it. They're going to discuss insanity later, and it's going to be very interesting. But that is an interesting tidbit. If he wasn't even enrolled, like, what's going on? Fighting other people's battles, vigilante justice? Is he Batman? Like, literally, what? Very strange twist, right? The delay, deny, depose. It's like, whoa, they didn't do that to him. Did they do it to a family member, a friend? There's so much context we still don't know that I would expect to come out as the case progresses.
Or he wasn't a client. And it goes to this idea of, one of the beliefs that I personally have is if he wasn't stopped, he might have been trying to go after other CEOs. Again, allegedly, if he really did do that.
And that's a great point, because somebody asked me that in my live and I was like, no, he probably wasn't doing anything else. Then once you put stuff together and you start to realize maybe that's why he was still carrying everything around with him. And it starts to make sense that maybe he wasn't done. There's no way to know unless he tells us, but maybe he wasn't done, which in that case, thank God, good job, law enforcement. Either way, if this is the guy who did it and if he was going to strike again.
I think there's a fair question about, was Brian Thompson his only target or one of many targets? Not entirely sure. We'll see where the evidence goes. It's speculation. And again, he is innocent. He is innocent until proven guilty. But the evidence we'll talk about in a second. I think it's crazy because when I talk about the public's reaction, it's being reported by WKEF that Peak Design, this is the company that made the backpack that was worn allegedly by the shooter, which was found in Central Park, that they have been receiving threats because there were rumors that the backpack helped police track down Mangione. So the CEO had to come out and say, look, we didn't provide information to police, and the backpack didn't have a unique identifying number either. So if that's true, that's crazy that they had to come out and actually defend themselves. But again, that's what we're talking about. And let's put that to a side for a second, because let's talk about the evidence. So the evidence in this case is, so far, authorities say the shell casings match the 3D gun that was found on Mangione, that Mangione's fingerprints match those found on a water bottle and candy bar that were found near the scene and presumably bought it at the nearby Starbucks that the suspect had gone to before the shooting. The surveillance photos of the shooter, including at the Starbucks, the hostel, near the scene, in the taxi, presuming they are all him, that he was allegedly found with a Faraday bag, fake IDs, suppressor, 3D gun. I won't even get into the writings yet, because Mangione was found with this manifesto and notebook that had these writings that could be problematic. But before we even get into that, Ben, just what do you think about that other evidence so far we have in the case?
Jesse, I think it's overwhelming, and I think that's why ultimately I think there will be an indictment.
Yeah, and on top of the fact that, let's go into the writings now. So Mangione was found with this manifesto, this notebook that had writings that could be problematic, that could be interpreted as a confession, although there might be ways to say that he didn't actually confess to killing Thompson. But here are the things the writing said. To the feds, I'll keep this short because I do respect what you do for our country. To save you a lengthy investigation, I state plainly that I wasn't working with anyone. I do apologize for any strife of trauma, but it had to be done. Frankly, these parasites simply had it coming. And then the writings go on to say about United Healthcare that the company has grown and grown, but has our life expectancy? No, the reality is these have simply gotten too powerful and they continue to abuse our country for immense profit. So, Ben.
So what's interesting about that is specifically, we've already kind of talked about that and read through that, but specifically mentioning United, would there have been more? Those questions kind of remain open.
When you see that, I'm struggling to make what the defense could potentially be. I've spoken to legal analysts who said insanity might be an avenue to go through. I don't technically see it because I think a lot of the evidence would suggest this is a knowledge of what you did, and escaping the scene seems to suggest, you know that you broke the law. But again, what do you see about what a possible defense could be here?
So they're going to talk about insanity defense now. And we broke down a little bit about what it was, knowing the consequence of your action, knowing what you're doing, what that knowledge actually means, understanding it, appreciating it. We're not going to do a full deep dive into how New York does it until and unless we find out that actually is the defense, which the defense will have to notify the prosecutors if they are going to go for an insanity defense. Let's see what Ben Chu thinks about it, though.
Yeah, I totally agree with you, because insanity would be a natural defense. I think in addition to what you cited, I think there are some writings to the effect of he did it with the gun rather than a bomb because he
Correct.
didn't want to kill innocent people. And that really shows, in addition to what you've said, that he understood the difference between right and wrong. And
it's a great point by Ben Chu, speaking like a prosecutor, right? Speaking like a prosecutor, digging at and picking apart an insanity defense in this case, just with what we know, realizing there's so much more we don't know. So much more we don't know.
That is a key component of successful insanity defense, that you have to show that he was incapable of distinguishing between right and wrong. And here, in his own words, he's saying, look, I know killing innocent people is wrong. That's why I did this killing in a particular way. I think it makes an insanity defense very difficult. And then I think you're left with what you opened this segment with which is jury nullification. Can we get somebody on the jury who has such an antipathy toward insurance companies or the insurance industry that they're willing to be disingenuous in the voir dire and acquit him despite what he's done?
I believe Thomas Dickey, his Pennsylvania attorney, had said that he wants to see what evidence New York has, because there are ways to fight against it, right? And so maybe one of the ways is to say, can we trust the ballistics evidence? How can we trust the fingerprints? Was there contaminations? Was it collected the proper way? There's different ways to just challenge the evidence. But overall, thinking about it, I mean, one of the reasons I think people are talking about an insanity defense is because of the outbursts made by Mangione. Like the idea of controlling a client. When he was being led to his extradition hearing in Pennsylvania, he made an outburst where he allegedly said it's completely out of touch. It's an insult to the intelligence of the American people and its lived experience. And it's being reported that his attorney, Thomas Dickey, in court in Pennsylvania, had to say to him, don't say a word. I'm the lawyer. I'll do the talking, because Mangione allegedly tried to say something. I don't know if that's that problematic if you're trying to argue insanity and he's saying this stuff. But B, how would you handle that? How would you handle a client like that?
Well, that's extremely difficult. And I think you have to be very hard with a client in that circumstance. That first of all, I'm sure he was warned before that to to be quiet. But the first time the client breaks that admonition, I think you make it very clear to him that you are going to seek leave to withdraw from the representation if he ever does it again, and that he's going to have to find a new lawyer.
Yikes. That's a little extreme. That's talking like a high powered civil attorney who can make those kind of threats. I mean, maybe lawyers would make those threats, but I think if you spoke out in court 2 times after we told you not to, it's like, I don't know how many lawyers, maybe some would withdraw, but it's like, guy, depending on what he does, okay? Like if he pulls a Diobra and goes and jumps the judge's bench, fine. But like just saying like, that's not true, or, speaking out, being frustrated in hearings or whatever, even after being told not to. It's like, sometimes we got to deal with difficult clients. I think that's funny that Ben Chu, it was like, you gotta, maybe you withdraw. And I agree with him. If you lose client control and your client doesn't listen to you or doesn't trust you and you start to lose the ability to work together, sure. You can either threaten or just withdraw from the case. I just thought it was funny. I do think after doing both and doing almost all civil now, I get where he's coming from. I get what he's talking about. The criminal defense world is a little bit different. Criminal defense attorneys have thick skin, are used to dealing with the most difficult clients. I would be surprised if that was the threat after just one outburst in a hearing.
The representation that you are going to seek leave to withdraw from the representation if he ever does it again, and that he's going to have to find a new lawyer. You've seen, I'm sure, in the recent proceedings with former Mayor Giuliani, he's had many outbursts in court. Now that's in the context of a civil case, but ultimately his lawyers did seek to withdraw, and the court ultimately did grant the motion to withdraw based on repeated outbursts where the lawyer said, "I'm your lawyer, Mr. Mayor, you must subside." But
my guess would be that situation's a little bit different, right? For about a million reasons we don't need to get into.
Going back to your question as to
also, I will say judges are much more likely to allow lawyers to withdraw at certain processes in civil cases versus criminal cases. Once you dig into a criminal case and you're far and deep in it, even if you want to withdraw sometimes, some judges won't let you, only under certain circumstances, which we saw so many of those in the Sarah Boone case. If you'd like to refer back to that, for all the different reasons lawyers and clients' relationships can fall apart.
whether that helps his insanity defense, maybe a little bit. But there have been a lot of clients you've reported on who have had similar outbursts in court who have not been deemed insane. So it might be somewhat helpful, but not necessarily. He may be just wanting to have this be part of his soapbox. And that may be one other thing, Jesse. I mean, putting aside the legal defenses, he may want to have his day in court to give forth in a very public way his manifesto. He may not care about his conviction. He may have already crossed the Rubicon in terms of, now that's not what his lawyer wants, but he may just want to have his day in court, not to prove his innocence or create a reasonable doubt as to his guilt, but to really expound on what he believes to be the evils of our healthcare system.
And maybe if we start seeing motions for cameras in the courtroom and things like that, he wants to broadcast this to the world. Maybe. I think it's a good point. It's a possibility.
Interesting point. And look, Thomas Dickey, his lawyer in Pennsylvania, told CNN about that outburst. He's irritated, agitated about what's happening to him and what he's being accused of. But there is a legal fight going on. So before I let you go, Ben, I just want to ask you real quick about extradition. So at the time of this broadcast, or at the time of this recording, I should say, New York Governor Kathy Hochul said that she is working on the appropriate paperwork to get Mangione back to New York because she said, quote, because that horrific attack occurred on our streets, the people of our city deserve to have the sense of calm that this perpetrator has been caught and he will never see the light of day again. Now, it's our understanding his attorney had been contesting extradition, but then Manhattan DA Alvin Bragg said last week, indications are that the defendant may waive, meaning may waive extradition, but that waiver is not complete until a court proceeding. And it's our understanding that
wouldn't be a surprise if this is true and he did waive for all the reasons my dad and I talked about initially. But, gathering information is important. Taking your time is important. Making sure you're doing things right and catching up as a criminal defense attorney, all really important. Those could all be reasons he hasn't waived yet.
Extradition, but that waiver is not complete until a court proceeding, and it's our understanding that might happen tomorrow. So Ben, he was fighting. Why do you think he was fighting extradition? Was it to give his legal team more time to prepare and for the evidence and see what might be there? And why would they waive it? Is it what would be the change in terms of their view on extradition?
I think he was fighting it to gain time, to find out, as you said, what is the quality of the evidence, what's the content of the evidence. Time is on his side in that sense. And I think why you would waive it is his counsel may have decided that he's already gleaned whatever intelligence he's going to get, and why wage a battle you're going to lose. And if my theory is right, and I'm not sure theory may be too strong a word, but if he wants to explain what his cause is, better to do that in New York than in Pennsylvania.
Yeah, and look, I should tell you, we don't traditionally have cameras in the courtroom unless there's exceptional circumstances. If the judge allows it, I do wonder, would that be one of these exceptional circumstances? Given the public's view on this, would the judge want the world to see the evidence being put forward in this case? We'll see. We're not up to that point yet, but I'll tell you what, Ben Chu is always with us, always here to break it down. Love your perspective. Ben, thanks so much. It was great seeing you.
Thank you, Jesse.
All right. So that's Ben Chu's take on it. And that's our reaction. So wild to also get the news that he was indicted in the middle of our video. You've already seen the clip at the beginning, but thank you guys so much for joining me. Make sure you hit that like button. Make sure you're subscribed to our page. Until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.